Good afternoon, everyone. Welcome to the 2011 Fulton Lectureship in Legal History, a lecture made possible by a gift from Maurice and Muriel Fulton. The Fultons are both graduates of the college, and Mr. Fulton earned his JD at the law school in 1942. Beginning with our first Fulton lecture in 1987, we have brought distinguished legal historians to the law school because of the generous support of the Fulton family. The Fultons join us each year at this lecture, and I've had the pleasure of meeting them here today. For those of you who haven't met me, I'm Laura Weinrib, the newest addition to the law school faculty. And it's really a tremendous pleasure for me to introduce our speaker today, Professor Hendrik Hartog. Dirk has various impressive titles, which I'll get to in a minute, but I should preface my introduction by mentioning the one that's most important to me personally, which is that Dirk was the advisor of my recently completed dissertation in history. And while that formal relationship is now over, he will always be a cherished friend and mentor. I haven't been at the law school long enough to take credit for inviting Dirk here today, but I'm thrilled to have been given the privilege of introducing him. Dirk is among the most unassuming people I've ever encountered, and so he seems to be embarrassed every time anyone reads his title, which is not unassuming. Dirk is the class of 1921 bicentennial professor in the history of American law and liberty at Princeton University. He is also the director of Princeton's program in American Studies. Before joining the Princeton History Department in 1992, he taught at the University of Wisconsin and Indiana University Law Schools. Dirk describes himself as obsessed with the difficulties and opportunities that come with studying how broad political and cultural themes have been expressed in ordinary legal conflicts. That obsession is at the heart of his scholarship, which he refers to as social history of American law. Dirk is the author of two books, Man and Wife in America, A History, and Public Property and Private Power, the Corporation of the City of New York in American Law, 1730 to 1870. He has also written a number of seminal articles, including The Constitution of Aspiration and the Rights That Belong to Us All in the 1987 Journal of American History, and of course his foundational and delightfully titled Pigs and Positivism in the 1985 Wisconsin Law Review, which is assigned in the first week of most legal history classes in law schools and in history departments, as well as many jurisprudence courses. Dirk's forthcoming book, from which today's lecture draws, is called Someday All This Will Be Yours, A History of Inheritance and Old Age. It will be coming out with Harvard University Press in the winter. Dirk's scholarship, which challenges received wisdom with a trademark air of intellectual playfulness, has helped to shape the field of legal history. But I also want to say a word about Dirk as a person, because if Dirk has taught me anything, it's that the traits of a great scholar and a great person go hand in hand. Dirk is an incredibly generous mentor, and not just of his own students. For a decade, he provided legendary feedback to prospective authors as co-editor of Studies in Legal History, the book series of the American Society for Legal History. Those who are fortunate enough to have received comments on book manuscripts, papers, and projects from Dirk, and there are a great many of us, know that he is a supportive and sympathetic reader, but also a spectacularly discerning one, and he is genuinely committed to moving the field of legal history forward. I chose to pursue my graduate studies at Princeton, in large part because my trusted law school mentor, Martha Minow, told me that Dirk was, in her words, one of the truly great people on earth. A sentiment I've heard echoed many times in subsequent years. So with that, I'll turn the floor over to Dirk, whose lecture today is titled Quantum Meruit and Old Age Care in American Family Life. And if there's time at the end, we will have a short question and answer session, after which we invite you to join us at a reception outside the courtroom.
Lies and lies. Thank you all, and thank you to the Fulton family and to the faculty and students of this great law school. Can you hear me all right? In the late 1980s and early 1990s, at the University of Wisconsin Law School, where I then taught, as well as at the University of Chicago and elsewhere, two intertwined perspectives about care shaped a great deal of work in feminist and feminist-inspired legal and political thought. One perspective had to do with how to conceptualize the uncompensated labors of women, usually as wives and mothers, within households. And that perspective was also often formulated with a sharper focus on the politics of caretaking. That is, on how to formulate a public duty to pay for care of the dependent and the disabled, how to pay for the care provided by usually uncompensated and almost always undercompensated women. The second perspective, on the other hand, developed a critique of the insistent commodification of many kinds of labor, including household labor. The first perspective argued that much done apparently out of love should actually be recognized as work and therefore should be paid for. The second perspective argued that much in the world ought to be done as understood out of love, or as done out of love, not as contracted for and commodified labor. The first perspective is strongly identified with the work of the distinguished philosopher Eva Kittay, as well as with that of my former colleague and friend at Wisconsin, Martha Feynman. The latter perspective can be identified with, among others, the writings of the legal theorist Margaret Jane Radin. Both perspectives have more recently been subject to important critiques by, among others, Chicago's own Mary Ann Case. Now, I was at the time more an attendee than a participant in these debates, but I found them then, and I still find them, wonderfully stimulating and challenging, thought-provoking. They offered perspectives that I thought fundamentally affected my life and that should have changed legal education. Time passes. In the early 21st century, after a period when I, like many of my generation, became immersed for the first time in the practicalities of caretaking, in the distinctive ways that caretaking occurs today, I suddenly discovered that in exploring a database of 19th and 20th century New Jersey cases involving suits for compensation by caretaking children and other family members, I'd returned to the questions that had so moved me a decade or so earlier. These cases were wonderful, marvelous, in the particular way that cases can be, at least for a legal historian, at least for this legal historian. They incorporated both all the theoretical and moral and political questions that we had talked about way back then, as well as a great deal of grungy and fascinating detail about the work of care. So a book based on my work, unpacking and interpreting these cases, is to be published later this fall. And the talk that follows is drawn from 2 chapters of that book. My goal here is to sketch lightly how the kinds of arguments that seemed new and novel in the law schools and in the women's studies programs and in the sociology departments of the early 1990s can be found in the routine discourses of the courts in the late 19th and early 20th centuries. I don't mean to claim that perspectives and understandings have not changed, but I do want to historicize and challenge the notion that in the 1980s and 1990s, we were talking in dramatically novel ways about new phenomena. So I'm doing what historians often do, revealing a longer and more complicated story, taking on a conventional wisdom that presumes our world and our understandings of that world are wholly new. And along the way, I think I tell some interesting and peculiarly detailed stories about family work and about how family work was talked about in the generations before our own. So the talk moves through 4 acts or sections. Let me just briefly sketch them. An introduction deals with the presumptions, the legal and cultural norms, what today are usually called default rules, that shaped the law of family work around the middle of the 19th century. I then offer a quick riff on the problem of what it meant legally to be a member of a household as an adult child as of the second half of the 19th century. I then offer a longer exploration of the ways early 20th century courts reformulated the identity of an adult child within a household. And finally, I finish by suggesting how, by the middle of the 20th century, labor by family members within the home gradually came to be understood as exceptional and unexpected, and therefore often or even usually deserving of pay. Okay, so here we go. Everywhere in 19th and early 20th century America, after older people had died, adult children sued the estates left by those older people for unpaid wages. Those adult children, daughters and sons, as well as grandchildren, adopted children, relatives distant and close, as well as unrelated individuals, brought actions quantum meruit, literally actions for as much as he or she deserves. From the perspective of those adult children, a suit for unpaid wages would often have been understood as a second-best alternative. What many of them had really wanted, the better alternative, was land or other property. That was usually what they had been working for. And in other chapters of the book, I explore the arguments rooted in the part performance exceptions to the statute of frauds and other doctrines that some lawyers developed as a way to get those children the land they sought. But it was not easy to turn labor in the home into a successful or judicially recognizable claim to property. What adult children would have to settle for, what they often would have learned from lawyers, was all they could get, if that, was a cash equivalent for back wages. In the trials that resulted, courts heard testimony about promises made and negotiations and wills drafted and changed and foregone opportunities elsewhere. And they heard much about quantities of work and care. But there was almost never a written contract put into the record. Written contracts, after all, were not an ordinary part of family life and of the negotiations that went on between family members. All that judges and juries had to go on were narratives about work done and explanations or reasons why people had worked. What were such narratives supposed to prove? What was the evidentiary significance of work in the absence of a written contract of employment? By the middle of the 19th century, such questions had a direct legal answer in most legal contexts. At least for free American adults who worked outside the home, work presumed a right to compensation. Or to put it somewhat more legalistically, quote, when one was employed in the service of another for any period of time, the law implied a contract of hiring and a promise to pay. A worker had a right to be paid for work actually done for the services rendered. When services were rendered, the recipient or beneficiary of those services, the employer, became obligated to pay, became indebted. Not to pay would be a form of unjust enrichment, of fraud. The law presumed that no one volunteered their labor. And if the employer had not paid for the work actually completed, the employer was liable. That is, the employer could be made to compensate on the basis of the work done by the hour, day, or month. Or if the employer had died with such accrued wages unpaid, then the executors or administrators of his estate were similarly subject to such an action. Either way, the compensation that resulted from a successful mobilization of the cause of action was understood as righting the wrong that had been done to an employee. Her or his employer had gained from the benefit of labor. For that, the employer ought to pay. Was that true within a family? Was that true for the kinds of work that adult children did within the households of parents and other older relatives? Here, a second default rule qualified or limited the initial answer. Quote, an agreement to pay for services rendered and accepted is presumed unless the parties are members of the same family or near relatives. As a New Jersey judge put it in a much-cited 1860 case, the law implies no promise to pay for services rendered by members of a family to each other, whether by children, parents, grandparents, brothers, stepchildren, or other relations. And he concluded that authorities for this proposition were so numerous that there was no need for any particular citations. This qualification was presented as if it were an expression of simple common sense. Family work meant non-compensable work, done for reasons other than expectations of pay. One family member could, if he or she wished, pay another family member, but not to pay for work completed or for services rendered did not imply the existence of an unpaid obligation or a debt unsatisfied. Work done in the home did not suggest the presence of an underlying contract for wages. When someone worked anywhere but at home, the inference, both culturally and legally, was that the work would not have occurred but for the expectation of pay, so long as the someone was a competent and free adult. Why would one labor for a stranger? except because of the promise of compensation. By contrast, when someone worked at home, although what was at home could include on the farm or in the shop, as well as in the bedroom and kitchen of the house, the presumption, again, both culturally and legally, was that the work came about because of desires and obligations distinctive to family life. After all, there were so many culturally significant reasons involving love, duty, sharing, and investment in the future that explained why one might have worked at home without the expectation of pay. Judges and lawyers and litigants alike regularly sang familiar, sentimental songs about the distinctiveness and the significance of the loving home in a variety of keys and registers. They knew, as all competent participants in the legal culture knew, that the work that made a home differed ontologically from commodified labor given and received by strangers. Outside of the home was where a judicially enforced contract law held sway. In the home, reciprocity, care, love, and duty shaped the commitments that came with intimate relationships. How then to adjudicate the claim to compensation of an adult child, the son or daughter or other relation, who had remained at home, even though he or she could have left to pursue opportunities away? Was the adult child still at his or her home? The adult child was not in a relationship of dependency. The adult child might well have his or her own family, children, and a spouse. In a society founded on mobility, where sons and daughters routinely moved away from their parents' homes when they became adults, what did it mean when they hadn't? Or when they returned to the parental household after a period of time away? Had home become presumptively a place of employment, with parents as employers, or did home remain home, in which labor occurred for reasons other than the expectation of wages? Now, the starting point for any legal analysis of these questions was that to be an adult child meant that one carried no legally enforceable duties towards one's parents. Children surely often, perhaps usually, felt obliged to care for those who had once cared for them. In theory, but almost never in practice, a town or other local government could require compensation from children if a parent were put on poor relief, had to go to the poorhouse. But parents had no inherent legal rights in the labor or care or the cash of their non-minor children. What then of the adult child who sued a parent or a parental estate for unpaid wages? Such suits produced a continuing conversation between judges and lawyers and litigants about the nature of the adult child. As an adult, that is, as a competent individual who might be either a worker or as someone who had been given the gift of care. Or was he a child, that is, as someone who continued to belong to a family or to a family member? Hard, almost metaphysically hard questions about freedom and care and duty emerged out of these easy, trivial, and common situations. What was adulthood? What did it mean to be in the family? What were exceptional tasks that would not have been undertaken but for the expectation of compensation? And what were voluntary undertakings? Or was a voluntary undertaking in its nature a gift? When an adult child took care of an older person, was it work? That is, was it free labor? Or was the older person and his or her estate freed of the obligation to pay? That is, was it free labor of a different sort? Now here is how L. DeWitt Taylor, a lawyer representing an intestate estate in an 1886 lawsuit, challenged the claim of a daughter in her mid-40s that she was entitled to be paid $3,000 on a note her now-dead mother had given her. The note was meant as payment for the daughter's care and work. But, according to Taylor, if obtained under the pretext that it was for services rendered by the daughter to the mother, it was void because the daughter never rendered any services to the mother, but such as it was her duty to render. That she was married and unemancipated, that she and her mother stood to each other in the relation of parent and child, that there was no express contract ever made between them that the daughter should receive compensation, that she was fed and nourished at her mother's table, that she was clothed and cared for at her mother's expense, that she was in feeble health a good deal of the time and required the attendance of a physician, for whose services the mother paid. In short, that the benefit she received from her mother greatly overbalanced any services she rendered. The key word in Taylor's argument was unemancipated. This was a term with a long and tortuous history, a history only loosely connected to the post-Civil War understandings that built from abolitionism, from the Emancipation Proclamation, and from the 13th and 14th Amendments, and a history almost entirely distinct from the emancipations identified with the 1960s. For Taylor and his audience of judges, emancipation defined the boundary between childish dependence and adult responsibility. The middle-aged daughter, who he argued did not deserve the money she had apparently been promised, remained a daughter, a child who lived in her parents' house, effectively a dependent, and thus he insisted she should not be paid. For us, the boundary between childhood and adulthood may be marked by a variety of events and transformations: the right to vote, military service, sexual maturity, wages, living on one's own, freedom from the authority of a parent, perhaps marriage. For both parents and children, the crossing of that boundary can be experienced as liberatory. Children are freed from the supervisory authority of parents, while parents may understand themselves as emancipated from duties of support. But for us, that boundary is fundamentally all about chronological age, about a birthday celebrated, about an age of majority. Although we still talk as if there were a vaguer but knowable moment of psychological and cultural maturation that might mark the switch. In the 19th century, chronological age, a birth date that marked the end of minority, was important as well. A father or mother could not demand that a child who had turned 21 remain to serve and care. At 14 or 16 or 18, depending on changing laws and mores, a father or mother could no longer stop his or her child from marrying. The daughter in the 1886 case in which L. DeWitt Taylor made his argument could have emancipated herself by marrying or by leaving home even before reaching the age of 21. Remember, she's well into her 40s by then. The court's opinion insisted that the note the mother had given her daughter constituted a just debt against the estate. The services that the daughter had rendered over many years since she had become of age justified it. But Taylor's language, as well as the court opinion, also carried the residual traces of a notion of emancipation that was functional. That is, about how and with whom one lived rather than formal and objective. That is, about having passed a particular age. This notion was rooted in a much longer and older legal history. In that long legal history, chronological age offered an imperfect marker of adulthood and adult power. The foundation of emancipation as a legal category lay in archaic understandings of patriarchal power. While a father always had the right to emancipate his son at any age, in much the same way as he had the right to open a cage and allow a pet bird to fly away, he had no duty to do so. Emancipate was something done or not done to a subordinate, sons and daughters, as well as foster and adopted children and apprentices, as an act of power and as an expression of a possessory right. Early on, it overlapped with notions of manumission, the right of a master to free his slave. Over many centuries, that older notion of emancipation had grown muted, even as it remained a presence in the law. Emancipation had become, quote, the naturally attainable state of having come of age and maturity, at the latest after 25 years. That's a 17th century definition. It constituted an ending to paternal power, and fathers and guardians could not retain permanent power over their adult children. By the 19th century, it had become clear that parents could not keep their children under control after they had reached maturity. Self-emancipation by the child, and Benjamin Franklin is the kind of classic example of this, even by daughters, had become something close to a legal right. Indeed, it became a contested judicial question whether parents had any continuing rights to the pay or to control over children who had left home to find work or marriage before the age of maturity, before they turned 21. And when the adult child returned home, he or she presumptively returned as a free individual, someone freed from parental power, someone who would only have come home to be in a work relationship as a contractor. That would be the case even if the child returned home at the demand of a parent who needed her or him. One could not become unemancipated. Yet did that mean that a 19th century adult child who remained within a parent's house, who had never left was necessarily emancipated? What of those who did not exercise the mobility that was becoming the hallmark of being an American? It was all a matter of presumptions. Absent evidence to the contrary, absent evidence that the relationship between parent and child had become a businesslike one, a child who remained in the household presumptively remained an unemancipated child, whatever her or his chronological age. Now, in theory, it was easy to overcome that presumption. There were a number of facts that, if presented in testimony, would be dispositive. But if nothing had changed in the work or marital lives of children, they remained children in the household. And in that case, they would not be likely to succeed if they later sued to be compensated for services rendered in parental households. Now, as one might expect, in determining the force of such presumptions, gender conventions and assumptions played a powerful role. Young men who gave up opportunities away from home in a free labor market to return or to stay at home were often recognized as presumptively entering into a contractual work relationship with parents. The presumption that a child remained a child within a parental household was easily overcome for them, less often for young women. As one judge wrote, quote, "The female children of many parents often remain unemancipated long after attaining majority, rendering services to the father and supported by him. For such services, there would be no right to compensation." Putting off marriage by a young woman was not understood by the courts as equivalent to a young man deciding not to go away to do for himself in the work world. Even when a young woman went away to work or to pursue a career, as young men did, and then returned, her departure might not be enough to secure her emancipation and to justify a later claim for compensation. In the case of Gardner's Administrator versus Schooley in 1874, a young woman, Sarah A. Schooley, had gone off to learn a trade. She stayed away from home, then her mother's illness and eventual death made it necessary for her to return. Thereafter, she stayed and served in her father's house, where she lived along with her brothers. Their father was a day laborer for the railroad, and he possessed a small house on a lot of 1/4 acre. His sons paid no board to him, although they did help furnish the house, nor did they compensate Sarah for the washing and mending that she did for them. And there is nothing in the case to suggest that they rendered any services to their father. Instead, the sons, whom one can read as effectively emancipated, whatever their ages, retained all their earnings for their own use. And Sarah served them as well as their father in the small house where they all lived. Her father, who had promised, quote, that if his life was spared, he would give her something to show for her services, eventually gave her a mortgage on the property. But when, after his death, creditors challenged the mortgage, the court ruled that she was entitled to nothing. There was no contract between father and daughter. Instead, the gift of the mortgage would, if held valid, have defrauded her father's creditors of their claims. The law would not imply any, quote, promise to pay for services rendered by a daughter to her father under such circumstances. Sarah had returned to her father's house while she was yet a minor to live in and be part of his family, and so she continued, unemancipated. The point is not that women who remain to care for aged or aging parents never won suits for compensation quantum meruit. In 1879, to take one example, a court affirmed the payment of $518 to the late middle-aged Catherine McCone for the care of her very old mother, who was 93 when she died. Her mother had fallen and was permanently lame over the last years of her life. Mother and daughter had always lived together, and Catherine had long taken care of her. She could have been understood as not emancipated, but the court concluded that there was clear evidence both that the mother intended to pay Catherine and that Catherine expected to be compensated. Since the mother would have had to pay someone, given her injuries, it was reasonable to suppose that she had agreed to pay the daughter. And by the time of this last case, by the end of the 1870s, the historically resonant language of emancipated and unemancipated began to disappear from judicial opinions. It is not surprising, then, that L. DeWitt Taylor's 1886 argument failed. By then, lawyers who wanted to challenge claims to pay by children and other care workers were looking to a different discourse. What was happening? Perhaps the courts could not resist the increasingly determinative power of age consciousness. It may also be that by the 1870s, inherited and long-standing legal understandings of emancipation were becoming increasingly difficult to articulate in the face of a constitutional polity now formally committed to universal emancipation. One discourse of emancipation overlaid another. The older language of emancipation had carried with it powerful but increasingly unacceptable patriarchal assumptions. The older language had rested on a belief in what Blackstone had once called the empire of the father, a belief that children ordinarily remained within private property-like domains of fathers and sometimes mothers. By the last third of the 19th century, however, a variety of cultural and political forces, including a women's rights movement, the beginnings of a child protection movement, new and expanded invocations of the police power that allowed at least some forms of public and semi-public intervention into the privacy of at least some households, challenged and worked to weaken parental power. As parental power weakened, the utility of the image of an unemancipated adult child apparently weakened as well. The last New Jersey decision that depended on a judgment that an adult child who had worked and cared in the home was unemancipated occurred in 1894. The decision served as the penultimate act in an endless and endlessly complex case about the estate of James Taylor, one of the founders of the Trenton ceramics industry. To simplify the story, the estate was sued by the creditors of Taylor's business partner, Isaac Davis, because Taylor had endorsed Davis's note. After having signed the note and not long before he died, Taylor had conveyed his large and recently purchased family home on Clinton Street to his granddaughter, Ella F. Severs, who would marry the same much older Isaac Davis after her grandfather's death. Davis's creditors argued that the conveyance of the home was an attempt to defraud them. Ella F. Severs Davis had also died by the time of the litigation, as had Isaac Davis, but her heirs at law, her siblings, argued that the conveyance was not made as a gift, which would have fallen under the rubric of an attempt to defraud creditors. Rather, it was intended as compensation for the work she had done in caring for James Taylor and his wife, for her grandparents. Okay, enough of that. That's too condensed to be even comprehensible. More than 30 years earlier, around 1861, when she was no more than 1 year old, Ella Severs had been taken from her own parents by her grandparents, and she grew up and spent her life separated and apparently sometimes alienated from her birth parents and siblings. When, more than 30 years later, the lawyers for Isaac Davis's creditors asked her father whether her grandparents had treated her as a member of the family, he answered, "Took her to serve and take care of them." They clothed her. They sent her to school, although witnesses disagreed for how long. According to her father, her grandparents pulled her out of school after 2 or 3 years because the old folks needed her to take care of them. According to several witnesses, the old couple had no servants in the household until close to the end. In other words, Ella had served her grandparents in their household, had substituted for the servants they had not hired. Ella's mother answered the question, "Who did the work in the house?" with a simple answer. When Ella was large enough, she done it. What was the nature of the work? General housework, including the work upstairs. Her grandmother generally did the cooking when she was able. But when both of the grandparents got older, about the time that they moved into the house on Clinton Street, Ella had to wait on them. When her grandfather came down in the morning, he was a man that could never fasten his shirt, and Ella would have to put on his pins and get his breakfast for him, to fasten his shirt together and do everything pertaining to their needs. Her grandmother was much disabled. She was a very large woman. She also had rheumatism. She went upstairs all right, but when she came down, she would have to come down backward and have to be assisted. Ella's mother tried to expand about the care Ella had offered to her grandparents, but the judge stopped her. He did not think that the quantum of care made any difference. This case was about whether there was consideration for the deed. As long as there was some work, it was enough. An attorney testified about having drafted the deed in 1886 that conveyed the property to Ella. It was done, he noted, for the services rendered by Ella. But to the judge in the case, the deed remained voluntary, that is, not founded on contract, and therefore the deed could be attacked and nullified as a fraud on creditors' rights. He came to that conclusion for two reasons. First of all, Ella, although she lived into her late 20s, had never been emancipated from her grandparents, from the two people who'd been the only parents she had ever known. Quote, "The relation which existed from the time the child was 1 year of age until she became 21 continued unbroken thereafter till her death." Perhaps he made things easy for himself by referring to Ella as James Taylor's daughter, not his granddaughter. But in the second place, he reframed the case through the lens of Disbrow v. Durand, a recently decided leading case of the New Jersey Court for the Correction of Errors, with an opinion by Chancellor Alexander McGill. The judge believed that this new case unequivocally confirmed the older doctrine about unemancipated daughters. But Disbrow looked at the question of compensation not in terms of patriarchal authority, but in terms of the expectations of members of a family living as one household. Within a household where people shared and lived together, it was the ordinary rule that such relationships abounded, quote, "in reciprocal acts of kindness and goodwill, which tend to the mutual comfort and convenience." Work within a household was ordinarily gratuitously performed. Where such a relationship appeared, the ordinary implication of pay for services did not arise, because the presumption that supported such implication was nullified. The mutual dependence of those in such a family did not rest on their status as parents and children. Indeed, such mutuality arose even where the family was composed, quote, "of remote relations and even persons between whom there was no tie of blood." All that Ella had done for her parents belonged to a world of care and love, far removed from the colder realm of calculation and individual compensation, symbolized by a deed as payment for services rendered. She had been part of a common family enterprise. As the judge in Ella's case had predicted, Disbrow quickly became a leading case, invoked and quoted relentlessly in New Jersey and in other states over the next half-century. The judge in Ella's case claimed that the opinion's significance lay in the way it reproduced and continued an older understanding. But in fact, the opinion initiated a new style of analysis in quantum meruit and related cases. In place of the need to invoke an authoritarian family, a prerequisite for a claim that a child was unemancipated, lawyers and judges reimagined the family as a place of sharing. Those who worked to resist the claims to compensation of adult children could now reframe those children as people who were confused about what was and what was not compensable work. Adult children could be denied not because they were still children, but because they ought to have understood themselves as part of a family life whose premises ordinarily stood in opposition to the world of work. One presumption, one default rule replaced another, the new one standing as a better reflection or invocation of what such judges and lawyers knew to be the real relations that shaped family lives. McGill's notion of reciprocal acts of kindness and goodwill offered a new way to characterize how and why work occurred in households. And that new way reflected a growing recognition, certainly for middle-class lawyers and judges, of the separation of economically remunerative work from predictably smaller urban and suburban households. In the world reframed by Disbrow, blood and lineage became almost irrelevant for the question whether household work was compensable work. Instead, courts asked, did you belong to the family or did you not belong? The household was becoming a site without remunerative work. That is, courts knew that there were non-household members, nurses, housekeepers, servants, who came to a household because it was solely their place of work. For those strangers, those employees, including those who came to do care work, the household was not their home, and they had presumptively, in the judicial imagination, left their own homes elsewhere to do work in the household. And they would be paid for their work away from home in this other household. By contrast, family members belonged to the home. They should not expect to be paid for the work they did at home, both because the work they did at home was not of the sort that paid workers did. That is, they were reciprocal acts of kindness and goodwill, and because the work they did at home was gratuitously performed, belonged to a gift relationship. The story that lay behind the actual case of Disbrow v. Durand encapsulated this emergent ordering. Sarah Disbrow, the plaintiff in the case, was the elderly younger sister of Smith Noe. She was 72 in 1892 at the time of the trial. He was considerably older when he had died a few years earlier. She sued her dead brother's estate to be compensated for the 20 years she had spent keeping house for him in Rahway, attending to all the work of the house and caring for him. According to her attorney, Sarah Disbrow had only lived with her brother because of a work relationship. She had never made her brother's place her home. Her home was naturally with her son, and both he and his wife frequently urged her to come to them. That's a quotation. At trial, Mary Disbrow, Sarah's daughter-in-law, had testified about the work Sarah Disbrow had done for Smith Noe. Housekeeping, washing, ironing, baking, churning, all the necessary work doing the housework. There were no other household servants, but there were other men employed by him on his farm, and she cared for their needs as well. She also nursed Smith Noe in his last illness, which lasted 3 or 4 weeks. Mary Disbrow, the daughter-in-law, had managed her own household ever since she had married Sarah's son 25 years earlier. So she qualified as an expert on what wages Sarah's services would have commanded in the local Rahway market. Quote, "Well, I had to hire such help and I had to give $12 a month, and I considered that not out of the way. It really ought to have been more." And she added that the pay scale would be higher if nursing were added. Sarah Disbrow's attorney had questioned Mary Disbrow, the daughter-in-law, whether Sarah, her mother-in-law, had ever resided in Mary's house. He clearly wanted to get as close as he could to an evidentiary conclusion that Sarah Disbrow had another home with her son and daughter-in-law, that Smith Noe's house was not her real home, that it was rather just her workplace. Unfortunately, the testimony Mary gave did not help his case. "No, sir," Mary answered. "I wanted her, she could not come. I needed her, but she could not come on account of keeping house for her brother." Thomas Schaffer, the lawyer who represented the estate, took off from that response in his cross-examination. What family did Noe have? He had no family of his own. He was a single man. Who lived with him? His sister, my mother-in-law. Did anybody else live in the house? No, sir. A little while later, Schaffer returned to the same question. Was not Mr. Smith Noe's house the home of Mrs. Disbrow? Didn't she make her home there because she had no other home? No, sir. Where was her home? With her son. How long had she lived with her son? Answer, never. She could not live with him. She lived with Smith Noe all the time. Yes, sir. Made that her home. Yes, sir. When Mary's husband, Sarah's son, testified that their house was always open to his mother, Schaffer asked him, who constituted his, that is Smith Noe's, family at the time of his last sickness? And the son had to answer, my mother and him. And that probably made it inevitable that his mother would lose her suit. Part of what must have made Disbrow into a striking result was the fact that it involved a suit by one sibling against the estate of another. In legal theory, siblings owed nothing to each other. The sibling relationship did not appear in domestic relations treatises as one of the domestic relations. Adult siblings were as strangers to one another, without enforceable obligations, free to contract or not to contract as the spirit moved. As adults, they did not belong to the same family. Sarah Disbrow was, in law, no different than any employee, a paid housekeeper who took care of an older man, even if that older man was her brother. And yet, in the Chancellor's opinion, she became a sister who had lived and cared for her brother as a loving member of his household, not as a stranger. If adult siblings could be made into members of a shared household, anyone could. The core of what Disbrow meant for the judges and lawyers who looked to it and used it over the next half-century was that it then provided a test. Those who lived together in a household presumptively dealt with one another as members of a common enterprise, one that precluded expectations of pay for services rendered. The legal question posed was whether a particular caretaker was a member of the family, or was she or he something else, that is, an employee. In 1907, to take a representative example, Annie Mullen married. Her parents were sorry to lose her, and they decided to work out a deal so that Annie would stay and take care of her mother, who suffered from rheumatism. They made a promise to the young couple that if Annie and her husband stayed, the place would be left to her. Annie's husband, when asked what he thought of that, said that he would have preferred to go to housekeeping, that is, for the new couple to have lived apart from her parents. But they negotiated, and there was an agreement that the new couple would not move to their own place. For the next 7 years, Annie Mullen's mother was able to move about the house on crutches and perform most, if not all, of her work. Then she fell and became more incapacitated. She could not leave the second floor, and eventually she became entirely helpless, unable to leave her chair, dependent on her daughter's care. After her death, her daughter, who was the administrator of her mother's intestate estate, allowed herself $4,000 as payment at a rate of $30 a month for the continuous care she had provided between 1907 and 1918. She justified her allowance on the theory that she had been promised the house and therefore she had moved in with a clear understanding that she would in the end be paid for having stayed. But when her allowance to herself was challenged, the Essex County Orphans Court invoked Disbrow. According to the court, until the mother's last 2 years, when the services she needed became equivalent to those that otherwise would have been provided by a paid nurse, what the daughter had done was to live and participate in a common household, and for that there would be no payment, and the daughter's allowance to herself was reduced to $1,500. Those who cared for the elderly but who had not been paid as employees would have to explain why they had not been paid and why they had still continued to provide care. They could not rely on any presumption that work implied a promise to pay eventually. Their relationship would not be understood as a commodified relationship. The language and the moral vision of Disbrow then permeated the strategic choices made by lawyers who represented estates and heirs against litigants suing for compensation quantum meruit. Watch, to take an extended example, what happened in 1915 when Julia Freen went to court after she was disappointed to discover that Cornelia Hudson had left her only a pittance. Julia had been Cornelia's companion. She had lived in Cornelia's household in Bayonne for more than 20 years, ever since she had failed her teacher's examinations in Staten Island, where she had grown up. She was no relation of Cornelia Hudson. Her parents had been Cornelia's friends. After Cornelia Hudson's death in 1913, at the age of 84, a codicil to her will was found to include a gift of $100 to Julia as an act of friendship, which she is to forfeit if she sues my estate. Julia, who had expected much more from the will and who believed that Cornelia's son, Edward Hudson, had fraudulently inserted the codicil into the will, protested. Edward, who was executor of Cornelia's estate, offered Julia $500 to pacify her. At first she accepted the offer, but later she repudiated it. And then she sued, asking for compensation based on 6 years' work as Cornelia's housekeeper and companion at $25 a month, plus 3.5 years of work as a nurse at $15 a week. A Hudson County jury awarded her $4,100. On appeal to the New Jersey Court of Errors, Elmer Demarest, the lawyer for the estate and for Edward Hudson, asked the court to reverse on the theory that the trial judge should have ordered a non-suit. His brief began by insisting that Julia had been practically a member of Cornelia's family and had always been treated as such by all the members of the household. Indeed, in a later passage in the brief, she was described as treated better than any other member of the family. No closer relationship can be imagined between persons without consanguinity than that which the respondent admits existed between her and Mrs. Hudson. Julia, the brief continued, was no nurse. She was 59 years of age, lame, and had no experience. She knew perfectly well that the services she was performing were given as though she were a member of the family. She was no servant. She ate at the table with other family members. She and Cornelia acted, if anything, as mother and daughter. Julia understood herself as possessing an equal right in the household with other members of the family. The main ground of appeal then was that Julia's admission that the position of the parties were in loco parentis barred her right to anything more than the love and appreciation she had received from Cornelia Hudson. Thus, there should have been a non-suit. At trial 1 year earlier, the work that Julia had done for Cornelia Hudson had been described by a maid. Help to do the cleaning, help do the housekeeping, running of the house, everything except washing and ironing. And then after that, Julia sat with Cornelia. She did sewing and crocheting and all the mending, besides waiting on Mrs. Hudson. She also went out on errands for Cornelia, who never left the house. The maid had overheard many conversations between Cornelia and Julia with regard to payment for services. Cornelia apparently often said she would give it to her, to Julia, if she had it, but she did not have it on account of her son, Ed Hudson, taking it from her. When he cross-examined her, Demarest had led the maid to describe how Mrs. Hudson and Miss Freen, and sometimes Edward Hudson, all sat down together at mealtimes. Two next-door neighbors had added detailed portraits of the work Julia Freen did, including material on her serving at the table, clearing, dusting, getting rooms cleaned, cleaning the silverware, and taking care of the son's clothes and his dogs. On cross-examination, Demarest had asked the first neighbor if she had ever seen Julia do any work that a member of the family would not do. The second was challenged to justify Julia's claim that she did the work of a professional nurse. Cornelia Hudson's physician had testified that he considered Julia to have been Cornelia's nurse and attendant. What nursing work had been necessary? He answered, Cornelia could not go upstairs or downstairs without someone with her. She was troubled with dropsy. Her limbs were swollen below the knees, making it almost impossible for her to get from chair to bed. I would not have considered her a safe woman in the last 5 or 6 years. Toward the end, she was not able to attend to her person. Most of the time she had control of her bowels, but not always. Then Julia attended and cleaned up. Julia, he had concluded, had been a good nurse, but he had thought there'd been much conflict in the house about the question of payment. Julia Freen had then testified. She too detailed all the work she had done. She did all the mending, and she would go out to do the marketing. She had expected to be paid for her time, but she wasn't, although she did receive $2 a week for taking care of Edward Hudson's dogs. After 1910, she had taken full charge of Mrs. Hudson's bodily care, bathed her every morning, clothed her, and fed her, and she had had to change her bedding. She did all the work usually done in an invalid's room. Demarest, the lawyer on the other side, had reserved the right to object to her testimony, since it was an open legal question whether a plaintiff could testify in her own case. But then he cross-examined her about her treatment within the family. He had her walk across the room to demonstrate how lame she was, too much so he implied to have been a real, that is, a paid nurse. She insisted that she'd been lame only for the past few years. They then went back through Julia and Cornelia's life together. She had been remembered at holidays with gifts, and she had given gifts to other members of the family, and she sat with them in the evenings. She was certainly no servant consigned to the back rooms. When Cornelia still traveled, Julia accompanied her, and they stayed in hotel rooms together. For years she had not been paid, but she did fancy work that she sold, and she paid for her own clothing. She described in detail all Cornelia's excuses not to pay her. Why then, Demarest asked, had she stayed? Because she never wanted me to leave her, and at last she was so sick I could not leave her. Cornelia Hudson was very fond of her, treated her as a member of the family, and she considered herself a member of the family. At that moment, one of Julia's two lawyers had Demarest repeat the question, presumably to give her a chance to realize what she was saying, since all knew that a family member had no expectation of pay. This time she answered that she was only treated as a family member by Cornelia Hudson, not by others in the household. The services were performed for Cornelia alone, and Demarest asked, you considered that the services you were performing for her were as though you were a member of the family, as of her household, did you not? Then she had answered, yes. He repeated the question, then moved on. Had Cornelia Hudson become like a mother to her? Yes, she was like a mother to me. You had no mother, had you? She had answered, no. The occasional spending money you received from her, you looked upon as spending money, the same as she would give to any member of her family. Julia answered, yes, between ourselves. He pressed again. You considered yourself, so far as she was concerned, a member of her household, did you not? Practically a member of the family, with the possible distinction that you were not a blood relative. She answered, no. She did not believe herself a blood relative, but she had felt on an equal level with other members of the family because of what Cornelia was doing for her and what she was doing for Cornelia. Yes, I do. At that moment, her lawyer tried to intervene on the theory that Julia evidently did not understand the questions posed or the implications that could be drawn from her questions. The questioning went on. There was much conflict about money in Cornelia's last years. Julia tried to raise the possibility that Edward Hudson had forged the codicil to the will. She insisted that Cornelia had promised to take care of her. Demarest had then returned to the question, what had motivated her to remain and to care? And up to that point, you were rendering to Mrs. Hudson these services because of your love and your affection and friendship for her, the same as you had done for a number of years previous, depending upon her to give you at the time she died some legacy? Her answer, yes, she always said she would. She had known she could not depend for support on the other members of the family. It was only when she found out how little she got that she had become dissatisfied. Until then, she had never expressed dissatisfaction. No, because she always said she would take care of me. You felt that you were living with Mrs. Hudson, that she was doing as much for you as you were for her? Answer, she died in my arms. Question, but you felt that the tenderness with which Mrs. Hudson cared for you and the fact that she was giving you a home from the time you had been unfortunate was equal to anything you could do for Mrs. Hudson in return, did you? Her lawyer intervened again because the witness was a little upset, and one can presume that he feared that she was about to destroy her case for compensation. She took a moment to compose herself. Then she answered, yes. One can only imagine the slumped shoulders of her own lawyers at that moment. On redirect, that is when her lawyers regained the opportunity to question her, they had worked to reclaim ground. Under their questioning, Julia described how, in Cornelia's last years, her nursing services took up every hour of the day. She would be up several times a night, and there was no one brought in to relieve her. When had she become lame? Oh, when I was taken sick, and then when I fell working for her and I was worn out working for her, and then I fell, and I've been lame ever since. It happened in 1911. How much had her fancy work earned for her? Only $40, earned one winter. On recross, under questioning again from Demarest for the other side, she admitted that if Cornelia Hudson were still living, she would not have sued. She had brought suit only because of the way she had been treated by Cornelia's son. This, once again, could be read as a concession that she had no contract with Cornelia. But then there had been one more set of questions from her lawyers on redirect. Why wouldn't she be suing if Cornelia Hudson were still alive? Because I expect I should be living with her yet, kept right on taking care of her. She did tell Cornelia once, though, that she would wait until she was gone and then I would sue her. I said I would not worry you now. She was worried enough. Now, it's important to note, this is one of the mysteries, that in spite of Demarest's efforts during the trial, in spite of her own concessions that love had shaped her conduct and her identity as a member of Cornelia Hudson's family, Julia Freen won. As is always the case, the written transcript cannot fully convey what the judges and the jury saw and what they knew to be true, and effective lawyering can perhaps go only so far. We can surmise that Julia's expressions of love for Cornelia did not, in the end, counter perceptions of the fundamental unfairness of the will. Demarest's interpretation of the law that no contract to pay can be inferred from services when the plaintiff was a member of the defendant's family was answered by the fact that Julia was not a relative. The evidence was not conclusive that the services she had provided were intended as gratuitous. There was a fair inference, this is all from the Court for the Correction of Errors opinion, fair inference to be drawn from the testimony that there had been an express promise to pay what the services were reasonably worth. And in any case, these were questions that could properly be submitted to the jury. Although Disbrow was not mentioned directly, one could infer that Julia Freen's lawyer had offered enough evidence to suggest that her work in the Hudson household could not be reduced to reciprocal acts of kindness and goodwill, which tend to mutual comfort and convenience. Gradually, the Disbrow standard was confined to those who were living together as part of a nuclear family, exactly what the case had not stood for when it was first decided. Over time, the Disbrow standard had narrowed. It had become easier for those who cared for older people within households to claim a right to payment, because the New Jersey courts were willing to define those who did the actual work of care as workers, not family members. And over time, as a reflection of moral and economic change, it became increasingly clear to the courts that old age care was something that ordinarily ought to be paid for. Was old age care still the work of a family, or was it becoming in its nature an exceptional task outside of the normal work that family members routinely did for one another? That's a question I want to now answer in the last part of this talk. But first, a quick interlude. Who were these 19th and early 20th century adult children? These younger people who sued estates for land or for damages, who insisted they were entitled to compensation or to property because of care they had once provided older people in family homes. How to characterize those who inhabited this peculiar middle space, who were neither family nor employees, or both family and employees. Despite a legal culture ideologically committed to keeping home and work apart, where work meant pay and home meant something else, courts in New Jersey as elsewhere struggled to fix identities that were multiple and contradictory. Often it must have been as confusing for the adult children as it was for those who had to judge them. We can imagine that these adult children lived at the same time in at least two moral universes. In one universe, that of the family household, they earned rewards, moral and spiritual rewards, as well as material rewards, by sharing in a common family enterprise. The material rewards of having invested in the family might be frustrated. Older people, those in control of family property, usually did not have to act in accord with promises made. The property owner, the parent, the older person retained the right to change his or her mind, to deny promised rewards. There was no legal duty to share in the end. And the fights after death might have ruined the moral and spiritual rewards of family life, at least retrospectively. But adult children earned rewards if rewards were earned by joining in, by being a loving member of a family unit. They justified themselves within that normative universe by showing exclusive loyalty, by submerging their independence as competent adults, by emphasizing their continuing place in the family, perhaps by continuing to be as children should be, even when they become adults. In the other universe, in the normative universe that a suit for compensation quantum Meruit articulated, adulthood, that is, rights and identities as independent and contractually competent actors, took priority. Subordination within the household was inconsistent with an adulthood that produced a successful cause of action, as was too much love. A good plaintiff's lawyer ordinarily worked to cabin a client within the second moral universe and to suppress the often multitudinous traces of the first. But as we've seen, the complexities of real lives kept leaking out into the testimony, and that made the lawyer's work difficult. Revelations of sharing and caring and love could become destructive to the case the lawyer wanted to make. Remember the anxious interventions of Julia Freen's attorney as she described her love for Cornelia. But in the hands of a clever lawyer, it was even possible to turn testimony about how subordinated, how submerged an adult child had been into support for a successful right for individual compensation. On the other hand, for those on the other side, there were many ways to mark adult children as greedy or ungrateful, that the younger people were morally obtuse or dishonest, forgetful of the primary moral universe in which they had actually spent their lives. Because of bad legal advice or because of their own moral deficiencies, these adult children had insisted on rights to property or to payment. Instead, they should have understood themselves as gift givers, not as crass contractors. They were people who had done good deeds as individuals in caring for older people. It sullied and darkened their moral status that they were now insisting on compensation for what they had once given voluntarily and freely, out of the goodness of their hearts, out of love. For adult children and their lawyers, there was only one effective counter to the charge that one was nothing but an ungrateful child, or worse. That was to describe in intense and often graphic detail the work of care. In almost every trial, testimony began with a description, usually by the plaintiff or petitioner, about the work done. And the lawyer would lead the witness through a description that emphasized what had made the work distinctive, exceptional, unusual, extraordinary, as something other than ordinary family labor. In doing so, lawyer and client were both marking the client's singularity, her or his right to special treatment within the moral universe of family solidarity, and at the same time revealing the client as an autonomous contractual actor. Lawyer and client worked to connect the client's life to still widely shared and culturally resonant understandings. We might call them labor theories of value, that certain kinds of work done made a client singularly entitled to work or to the benefits of a promise. In 1899, to take one peculiar example, Henry Cullen sued the estate of Asher Wolverton as the assignee of the quantum Meruit claim of David Lawshe. Lawshe was married to Wolverton's stepdaughter. He had called Wolverton father, and Wolverton had treated him, he said, as a son. And testimony in the case began with Lawshe on the stand to tell his story about the work he had done for Wolverton. Asher Wolverton may have been around 80 in 1893. In January of that year, on a cold and foggy morning, just a little while before church service time, he had fallen down a stone pavement and broken his hip. From then on, he suffered from chronic trouble with his bowels, requiring frequent injections or enemas. Only Lawshe was allowed to help him. And frequently, while Lawshe was giving him his injections, Wolverton would say to him, "Dave, this is a very unpleasant job, and you shall be well paid for it." What had Lawshe done for Wolverton? I'm going to pass over the gory details that were elicited and elaborated on in testimony. Let me move on to the question, what was such testimony supposed to prove? The simple answer is that it demonstrated that Lawshe was not doing what a neighbor or a friend or a household member ordinarily did. He was doing something peculiarly repellent, something that a man certainly, but a woman too, would have been unlikely to do without a pre-existing understanding, an agreement, a contract. Because of the exceptional nature of these tasks, because of his exceptional labors, he became something other than a member of Wolverton's household, or a friend or a neighbor. As the judge put it at the end of the trial in charging the jury, if what Lawshe had provided were mere neighborly services that one man would render to another, then there could be no claim. But that was certainly not the case here, and the jury gave a verdict for Lawshe. From the earliest case where a court ordered specific performance for a promise for care, an 1846 New York case brought by one brother for the care of a brother subject to epileptic seizures, exceptional tasks or labors were mobilized to justify a right to compensation. In quantum Meruit cases, the exceptional provided an explanation why one was entitled to something more, to compensation in ways that differed from the ordinary compensation for having lived as a family member. The exceptional moved the description over into the second moral universe, the universe of contractual obligation, and away from the first, the universe of family love. The exceptional also solved the problem of proving an underlying oral contract. Tasks that were exceptional, like those undertaken by David Lawshe, were not ones that could be explained except through the lens of contract. Ordinary and routine household duties, ordinary and routine care belonged presumptively to the realm of Disbrow's reciprocal acts of kindness and goodwill, which tend to mutual comfort and convenience. Not so when care became intense and personal and arduous, when older bodies and minds fell apart. Over time, some of the seemingly ordinary and routine work that women did, housework and nursing, gradually became tasks presumptively subject to market standards of compensation. That is to say, over time, more of the work that women did as members of the households of others, whether their parents' households or the households of employers, and became understood as exceptional, unusual, unexpected, unexplainable only through the presumption of a pre-existing agreement. The starting premise in the middle of the 19th century had been an understanding that housework was just that, housework, all of a piece. Unless previously specified, there was no reason to distinguish one part of the complex whole that was housework from another. And women who did work for pay were expected to adjust to shifting demands and tasks as the needs and demands of the household changed. For most women, indeed, ordinary nursing was understood as part of the package of goods and services that were incorporated into the term housework, although what was ordinary and what was extraordinary was a matter of continuing litigation. Nursing was both a general skill peculiarly identified with womanhood, and by the end of the 19th century, it was becoming a distinct skill that had a clear and growing market value. One result was a good deal of conflict over the rights of married women to charge for nursing services. In Gerritsen v. Appleton, one case among several where a wife insisted on compensation, a wife brought a claim against an estate for nursing services. Peter Van Pelt had been the landlord of her family house in Perth Amboy. He had moved in with them in 1891 to get a kind of attendance or care he could not get at his home. The nursing Christina Appleton provided was all agreed arduous, exacting, and sometimes of a repulsive character. She was, according to an attending doctor, an excellent nurse. Van Pelt's dropsy, excuse me for this, but I will, meant that his testicles had swollen to huge dimensions, as big as a small muskmelon and as black as ink. His scrotum and testicles needed constant washing and bandaging. She had to get him out of bed and to and from the stool. She used a liniment on his sores that his doctor gave her, made of alcohol and red peppers that burned the skin off her hands. What she did, according to a doctor, was worth around $3 a day. And after a trial, a jury awarded her $964. The problem the case raised was that Van Pelt had made a bargain with Christina Applegate's husband when he had first moved in with them. The contract, according to her and her husband, was only for board, meaning there was no agreement about nursing. But according to the other side, according to those who represented Van Pelt's estate, the bargain had been for both board and nursing. Actually, since he had moved in with them because he was not receiving appropriate care in his own home, it seems unlikely that nursing was not contemplated. In light of that bargain, could she bring a separate cause of action apart from her husband? According to Christina Applegate's lawyer, it was appropriate that she bring this case in her own name. The husband had done no nursing, except for occasionally helping to move the old man from bed to stool, as any husband would have done. He was an oysterman and boatman, not a woman, not a nurse. But such facts were quite irrelevant, according to the defense. What she had done, the services she had rendered, were in the discharge of her duty as a wife, and thus were incorporated into the contract Van Pelt had made with her husband. A wife's right to her own earnings under the new statutes that limited coverture were restricted to those that derived from a regular calling, and nursing in the home was not such. More, according to the defense, her husband had signed an agreement that we would bring no claim against Van Pelt's estate. When the husband was asked whether the we meant that the wife accepted and signed as well, he answered, "No, sir, I never consult my wife about my business matters." And he insisted that the we was a simple mistake. Christina Applegate had apparently believed that Van Pelt would leave the house and lot on which they lived. Leave her the house and lot on which they lived. She was, as such, speculating on a legacy. And what she had done for Van Pelt, if viewed as outside or beyond her marital duties, was properly understood as gratuitous and voluntary, not compensable. Her services were at most, or at best, just a gift. Over time, though, nursing, which had long been understood as an undifferentiated part of the package of services that women as employees and as family members provided, became a specialized task, became separately compensable work. The care and attention that disease and decrepitude required were less likely to be viewed as predictable and ordinary family responsibilities. Nursing as such belonged to a labor market, and it could be measured and paid for with reference to that market. And nursing and intimate bodily care work gradually ceased to be tasks that daughters and younger women and ordinary domestic servants generally expected to assume as part of the unspoken understanding of their jobs within households. And to go one step farther, by the post-World War II world, the ordinary activities involved in staying home to care for elderly people, cleaning, cooking, comforting, were becoming understood as exceptional in their nature, not as normal things to do, even for daughters or daughters-in-law. Such activities presumed an underlying understanding that compensation would be paid. That is, courts were learning to view the undertaking to care for an older person as carrying with it a presumption that it must have been an undertaking premised on a promise to pay. And one might say that is the end of the story. The older understanding that work within the home constituted an exception to the presumption that all work was paid work was apparently no longer operative. Claimed promises that had once seemed unproven or unprovable or legally uncompelling had now become more believable and more legally compelling. Thus, in 1952, a daughter-in-law's claim that she had been promised pay for the care she gave to her husband's parents over most of 2 decades seemed entirely believable to the New Jersey Superior Court. Soon after her marriage in 1933, she began going to the apartment of her in-laws where she did the housework, shopped for the couple, cooked their meals, and acted as their practical nurse. Both in-laws were overweight and sickly, and the daughter-in-law cared for them and their needs through the day. Those who resisted her claim had argued that because the plaintiff was a daughter-in-law, the services she had rendered must have been offered without expectation of compensation. The court made short work of that argument. The court worked to distinguish the facts in this case from those in Disbrow. The daughter-in-law had lived with her husband in their own apartment, unlike the sister in Disbrow, so she had a separate residence and was not part of the same household. But the case also carried the inference that the very fact that she did so much work for her in-laws suggested that the in-laws must have expected or had led her to believe they expected to pay her. If she weren't expecting to be paid, she wouldn't have stayed to work and to care. No one, certainly no daughter-in-law, would have done so. As of 1952, we are not yet in the America familiar to us in the early 21st century. An America where direct care of the decrepit and the more or less helpless old is presumptively provided by way of paid contracted work by strangers, many of whom will be employees of large corporations, health providers, nursing homes, or insurance companies, among others, or of governments. We are not yet in a normative universe where the needs of the old will be serviced by global armies of migratory workers who do aspects of the work of care that most family members no longer imagine doing. But we are entering a normative universe where the default rules had changed. In the post-World War II world, direct care of the old was not something done presumptively out of love or guilt or habit or sense of duty. Which is not to say that there were not many who would not continue to do for others, to care, out of love or guilt or habit or sense of duty. But in the courts, in the law, care work for the elderly was increasingly understood as belonging to a commoditized universe of pay for services. And yet nothing was really settled. And as our law school debates of the 1980s and 1990s revealed, we still today feel the pull of competing and contending normative universes. Family work is still incompletely commodified. Adult children remain uncertain what they owe and what they are entitled to. We still wish things were different than they are. Thank you.
Just curious about the question of how much these cases make a difference in terms of the general pattern of behavior. That is, we would expect under the sort of general theories of litigation that the cases that are going to be litigated are those that are most close to the line. And so if you were to look at 1,000 cases in which it turned out that people took care of their elderly, and there was some ambiguity as to role as to whether it be business or family, how many of those were resolved amicably? How many times did the wills provide the money? Did the house actually go to the next generation? Did the heirlooms take place? Because my sense about this is that most of the time these things probably worked out and that the litigation was representative only of those cases where there was some misunderstanding and not routinely representative. Is that true or is that true?
Obviously that's true.
Yeah.
I mean, but it's not, but there's two things to be said. One is that the trial transcripts are, just thinking as a social historian, incredibly rich pictures of how work was negotiated within families. Now, you know, how does one get access to that except through these kinds of sources? I don't know. So one answer is, you know, of course you're right. And I'm not making a causal argument that the law may, in fact, I would rather make a, you know, call it a Friedman-like reflective argument that these are reflections of anxieties and tensions in the society. You know, clearly, these are deals gone wrong. There were deals that, I mean, you know, as I think of them, there are at least 4 universes of cases, of which this is only one. I mean, one is everybody did as they were supposed to do. They paid who they were supposed to pay. Everybody went home happy. You know, happy is the wrong word. The second is one which I'm sure was deeply gendered, which is that a lot of young women lumped it, didn't get what they were promised, and accepted it maybe because of pressure from siblings, maybe because they didn't get legal advice, you know, for any number of other reasons. There is some world of cases, again, not ones I can do anything with, where people didn't expect any compensation at all. Yeah, and then there's lots of ones where there's no property. You know, and so if you take those 4, that, you know, that's, but these are, I mean, part of what drew me into the project, I mean, is just the social historian's pleasure in incredibly rich sources.
No, I agree with that. The question is, if somebody were to look at probate records, right, of non-litigated cases, would they find a pattern from which you could then infer, yes, she took care of it for 20 years?
You find nothing. I've tried to sort of go through probate records in several counties. There is nothing that reveals this world. So you take what you get,
Yeah.
and then I hope I qualified and.
No. This is not a disagreement. I'm just trying to figure out how efficient the system was overall.
Yeah.
You can't figure out the.
Yeah. That's it's the historian's problem. You take what you get. Yeah.
Can you put your records in a slightly larger context, both in terms of time and maybe geography?
Yeah.
I know that's really unfair because you've been engrossed in these records, but any sense of when these cases started, or whether or not these were typical patterns across the country or parts
I
of
think
the
they
country?
are. There are. Well, particularly this chapter, the material on quantum merit, I think it's the same everywhere. I think wherever you look, you would find the same, and you would find hundreds of cases wherever you look in the country. So I mean, one response to the last point is that these may be outliers, but there's a lot of outliers. There is a lot of conflict, partly because of the cross-generational, partly because the probate moment is a moment when people are encouraged to litigate in a way that they're not. In part, I started out thinking I was going to do either a national or do several different states, and finally just realizing that I had 250 of these cases with these kinds of transcripts in New Jersey, it became a narrower project. There are differences in state around the land questions and the equity court questions. There are more differences between jurisdictions than about the quantum Meruit cases.
What about the time?
There's a mystery in the time. I mean, I think, I argue in the book that the market revolution, that you need a mobile population of younger people in order to create these cases. That is, the children have to feel, that is, the parents have no automatic hold on their children's labor. They have to be in a situation where they really have to negotiate with those children. The cases all start appearing around 1850, which fits a kind of market revolution kind of argument, but I can't, but they do just appear. And there are very few cases prior to then. Is this some kind of, is this selection effect stuff? Is this because of peculiarities about the courts? I don't know, but they do appear all over the country in the 1850s, and they disappear around 1950. So you can say, sort of with the modernization of old age care in the last part of the 20th century, this is a world before Social Security, pensions, large-scale health insurance, and things like that. That's the best I can do. It's very inferential. Yeah.
So it sounded as though there were maybe two possible theories at work in these cases. So one being that there was in fact a contract, stated or unstated, implicit or explicit, and the other being that just as a matter of fairness and unjust enrichment, even without a contract, the plaintiff was entitled to some money. And did the courts distinguish between those two theories, or is there any?
They're very fuzzy. And I think if you read quantum merit cases, they're always wandering back and forth between those two. I think the unfairness is what drives certainly what drives the jury verdicts, but they wander back and forth around that. Sometimes that's different again in the land cases. They're really trying to find an implied contract, but in the quantum Meruit labor cases, they want. This is soft law. this is fuzzy law. There's the hard doctrinal work that you all do so well is not done in most of these cases. Yeah.
Is there any difference in outcome when the sort of competing claimant is a third party versus when it's the other children?
Well, what is third? The problem, part of the problem. What?
Creditors, outside creditors. I mean, that's
Oh.
what I think. You know, you were talking about this.
When you've got creditors, you know, if so, I didn't catch it.
I spent a lot of time worrying about how did housekeepers or more distant relations deal as compared to direct lineage, children or grandchildren. I spent a lot of time with that. The creditor cases just constantly appear. I mean, clearly this is how a case came into being. Do they come out differently? I don't think so. But I mean, creditors' rights obviously is a pretty strong value to the courts, and so it could be. Yeah.
Could you say a little bit more about the overlapping discourses of emancipation? Because it strikes me that the 1850s is significant not only from the market revolution standpoint, but from the rise of abolition.
Yeah. I mean, the cases just wander on labeling, in the 1850s, 60s, and 70s, they wander on labeling a child unemancipated, and sometimes it's a child who's 60 years old is labeled as unemancipated. It's again, this is deeply gendered. If a daughter hasn't left the house, if she stayed to care after mom died, she will be understood as unemancipated. But that language, I think both, I can't find the moment, I can't find a law review article that says stop using the language of emancipation. But it just, you can tell in the 1880s and 1890s that language just disappears. People stop, my guess is you can't say it to a jury without looking foolish in a post-emancipated, post-Civil War world. I'm just guessing, if there was a trial tactics seminar, this is that you could find the records of, you would see that discussion. I know this. Go ahead.
Well, I'm just struck that at one point you noted that there was sort of understanding that adult children did not have an obligation. And I'm wondering if it just seems remarkable to me, the period of history you covered, that there is not a piece of any of the discussion which is thinking about the obligations of children to their parents.
Well, there is constant, it's all, I think the Disbrow standard is an attempt to re-articulate that standard. It's just not in the Anglo-American doctrine as a part of the the baseline legal understanding.
So the court's not confronted in anything that is sort of an explicit sort of embracing of the question. Is there?
No, they just.
Yeah. So, what about cases where the adult child has a trade? So obviously the perfect case to come across, and it may not show up in your sample, would be this physician adult child. But set aside those sorts of cases because they probably wouldn't show up in the sample given the gender dynamics of medicine at the time. Sort of skilled tradesmen and the sorts of services.
So a physician
exactly, or a carpenter for that matter.
Oh, it happens all the time. What else is the young woman who's a nurse? She is, after all, doing a skilled trade. She just happens to do it in the house. It comes up constantly, and I think it raises real anxieties for the courts on both sides, because obviously it's easy to resolve for the men, especially where the man has gone away and acquired a trade or has a trade somewhere and then comes back home. Then, in a sense, you can't be unemancipated once you're emancipated. So if you are emancipated, then you come back, and then there's a presumption. What we're talking about are presumptions. They can be countered, but the presumptions become clear that you are a contractor. It's much harder for women to make that kind of argument, at least within the sort of work world of the time. Not impossible, and you do see it. Yeah.
Are you familiar with, either directly or indirectly, with any differences in the way the role of the woman is regarded by culture, country, state, a different viewpoint on the thing we've been talking about, depending upon who you're talking to.
If you're asking, I mean, there's a lot of ways of carrying. And one of the questions would be about ethnicity, and different, coming from different languages. One of the things I've found striking, and I think I want to write an article about this, is that there was much less difference between ethnicities on these questions than I expected to find. I mean, New Jersey is always a very complex place, so there always are, many different nationalities in there. Almost all of the litigants I deal with are white. There's a couple of African Americans, but they're almost all white. But they are lots of first generation, lots of recent immigrants, and the differences are smaller than I expected. There is less difference. I think the power of testator's freedom, the power is, or it's a very seductive thing in the culture. I don't know if that's exactly what you're asking me. I can't. There are obviously differences. If you looked at European practices around these questions, you would see very different practices in different jurisdictions. From what I know of Sweden, from this recent work by Maria Agren, though there's a lot of, though they come out of a culture of intense family solidarity, by the early 19th century, it's intensely individualistic, and everybody is understood as a free contractual actor. My sense is Germany is almost exactly the opposite, but that's only from reading secondary sources. So I'm probably not giving the answer, a good answer.
Thanks, Dirk, for
sure,
a
Thank you.